serving my clients. And I finally found Copenbarger.
I've learned over the years that you do business with people you like and you trust, whether it's the gardener you're hiring or it's your surgeon and certainly an attorney. And what we found when we walked through the door was that pretty much immediately we loved the people here. And that's why we chose Copenbarger.
Without our team of people, we're nothing. We have the best attorneys you can ask for, the greatest education and credentials, but without that team of people, we're not anything.
So not only are you servicing the client, but the fact that everyone cares about each other unites us as one group, and it's pretty exciting to be on a team like this.
The Copenbarger firm is an outstanding firm. They are very generous, they are the most kind people, and they have done an outstanding job for my husband and I.
It was some 20 years ago. We made an appointment and we came to the office, and that's when we met Larry Copenbarger, who was an outstanding man.
We have become a family over the years.
I was really taken by his hospitality, his warmness, and that's how we became friends.
We're keeping that in mind when we're bringing new staff on board, that they recognize that in order of priority, it's serving first. So it's not just about their technical skill, it's really about making sure that they're a good fit culturally, and that's what's ultimately going to lead to a successful transition of Lloyd's legacy.
Someday I'm not going to be here anymore, but the people who have relied on our representation will be. And I know the people that are the clients of Copenbarger will be taken care of in the future just as well by the other attorneys.
When you hear it from our clients, they feel like they're cared for here, and I think to come in and want to change that, I came here because I want to care for them and I want to keep this legacy going.
It gives you a great sense of satisfaction that what you're providing to your client cannot be surpassed. Maybe equaled by some law firms, but definitely not surpassed.
I'm very, very confident in the work that they do here, and my experience has been tremendous.
I believe sincerely when I look at the future possibilities of this firm that we can impact thousands of families, just like we have for the last 40 years.
Every night when I go home and I look in that same mirror, I can say to myself, you had an impact in some people's lives today that will make their lives better. Now, how does it get any better than that in life?
Alrighty.
Oh, there we go. Okay, no feedback. Okay, can everybody in the back hear me? Sounds okay? All right. Couple of housekeeping things before we get started. If you didn't find the restroom already, nope. The restroom is going to be out the door to your right and then left, so it's just at the end of the hall. Temperature-wise, if it gets too hot, too cold, talk to this guy. This is David. He's going to help keep, hopefully, the temperature in here relatively regulated, because obviously, we have a decent number of people here today. I might have to yell at you guys. I'm so sorry. All right, so let's get you started. For those of you who don't know me yet, my name is Victoria. I'm one of the estate planning attorneys with the Copenbarger Law Firm. But I am only one of our attorneys. If you have not been back to see us in a while, or frankly, even if you have, we have a lot of new faces with us. The reason for that is Copenbarger doesn't just do estate planning. We, of course, focus on estate planning and the foundations, but we have other departments and other attorneys who are there to walk alongside our clients as needed, because estate planning can be more comprehensive for people. One of the departments we have is our business tax and advanced planning department. So if you have rental properties, if you're a small business owner or a large business owner, if you have a higher net worth, you're concerned about taxes, as a lot of us often are, we have the team that's going to be able to help you with that. You're going to hear from Catherine Grout today, who is part of that team. She'll go into more detail. We also have our estate administration team. You're going to hear from Megan Wilson today. That team is there to walk alongside either you or your loved one once someone has passed away, because at some point we know we won't be here any longer. And when that happens, it's often very overwhelming of, okay, now what? What do I have to do for California? What is this trust telling me to do? I'm also grieving, so how do I get my head right as I'm going through all of these things. And that is where our administration team comes in, and they can actually do a lot of the things somebody either doesn't know how to, doesn't have the time to, or just flat doesn't want to. Now, most of what we talk about today is how to avoid litigation. We do not want you in court. We do not want your estate or your family in court. Unfortunately, we do know, though, sometimes people want to fight no matter how well you planned or how fair things are. So we do have Elaine and her team who can come in and help if anything does need to go to court. But again, a lot of what we talk about today is how to avoid that. As attorneys, though, we could not do what we do without our incredible staff. So you got to meet Caitlin as you came in. We have David. We have our CEO, Chris, here. It's absolutely a team, and it's what's allowed us to help so many clients for so long throughout the full state. And then we have offices all over the area. So most likely, if you're sitting here today, our Sacramento office is where I would be meeting with you. We can also do Zoom. We can do things by the phone, especially if you have quicker questions. But if you move or you have family in other areas, odds are we have a physical location near you or near where you will be. All right, so if you have been to a seminar before, you likely know we go through a lot of information and we go through it relatively quickly. The handouts that are in front of you, I very strongly recommend that you take notes take notes in them, write down your questions, use those to flag when you come in for a consultation. This is what really stood out to me. I have questions on this topic. It ends up really helping hone in what you took away from today and helps ensure that we're really answering those questions you leave with. All right. So bear with me. I'll keep pausing if the volume cuts out. I won't just keep chatting away. So for this first portion, if you already have an estate plan, this is going to be a good recap of why the plan you have is so important, but it's also a good reminder of why it needs to stay up to date. An estate plan is not a do it once and never look at it again. It is a take it out sometimes every year, but we recommend at least every 3 to 5, and that you also in that 3 to 5 come and meet with us to make sure it's still doing what you intended for it to do. Because as your life changes or as the law changes, the estate plan may need to as well. For those who have not yet taken the first step into estate planning, or you're just starting that step, this will be a really good crash course in what documents you actually need. Why are they so fundamental, and why is it so vitally important that you have them in place? So when we're talking estate planning, it's not just a one-stop shop. It's not one document and you're set. It's often a very comprehensive set of documents because each of them is playing a very important role in protecting you. A lot of people think about estate planning as what happens when I die? Where does my stuff go? But what happens if you become incapacitated? Who takes care of you? Who has authority to take care of your money? That piece is often overlooked, but is crucial. So that's the part we're going to start with. If you are over 18, which outside of my daughter and one other, I think pretty much everyone in this room is, you need an advanced health care directive. The reason is once someone turns 18, no one has an automatic right to make your medical decisions. So if you cannot verbally give a doctor authority, it needs to be in writing. That now includes your parents, if your children are old enough, your spouses. Again, no one has this automatic right. So it needs to be in writing. The other thing is it needs to have been done since 2004. If you have a healthcare directive that was done pre-2004, it doesn't have HIPAA compliance language that needs to be in there. If it's been done since 2004, it should have that statement and be fine. The third thing though, with all of our estate planning documents, very bluntly, you can find most of these online for free. But what free equals is cheap quality, unfortunately. And a lot of times it is cutting out the crucial components that can make or break a difference for you and your family when the time comes. One of the things with our healthcare directives is they're very comprehensive. They go through questions like, do you want to donate organs? Do you want to be buried, cremated, or something else? Do you want life support? That third one in particular is a huge thing to have answered ahead of time. Not only because it means you no longer can communicate, so by having it in writing, you're still having that control, but having been through this personally, having somebody already decide that takes the weight and the grief and the guilt a little bit off, especially that last one. It is not a fun question to be asked of, do you want to remove somebody from life support? But my grandma had already made that decision. And so for me, it wasn't me choosing, it was just honoring what she had decided. And again, having lived that, have a comprehensive directive that answers those questions. Again, not just to protect you, but to protect the person who you're appointing. If you already have a healthcare directive and you have not looked at it in the last 3 to 5 years, pull that thing out. Make sure the people named are still correct. Make sure the choices made are still accurate. Because again, when this is used, you're generally vulnerable. And so for all of the documents, making especially sure that those people who are going to be taking care of you or the money really are correct, because you're putting a lot of trust in that person's hands. We can help you review those though, so if you're not sure where to start, bring your plan into us and we'll help you go through it. Now, one thing to note, if you don't have Kaiser, you can ignore me, but if you have Kaiser, Kaiser has started requiring specific language that has to do with when the people named are allowed to act using that directive. So if you have Kaiser, you haven't seen us, I'm going to say just in the last year. 2, you might be safe, but let's say in the last year you have not seen us. Come in, let's take a look at your directive so we can make sure you have that language. Good news, especially for Access members, that is a free update if you do have Kaiser. So if you're an Access member, definitely do not hesitate to come and see us. We can get that taken care of quickly. For all others, it's a very small change. It won't be much, very quick as well. The next one we need. This is your durable power of attorney or financial power of attorney. So again, this is crucial when you're incapacitated. It's who can now manage my finances. Now, a lot of people assume, well, my spouse can. They're on all my accounts. They're on the house with me. The problem becomes, what about your retirement accounts? Your spouse is often just a beneficiary. They're not a co-owner or co-manager, which means if you can't give that authority and they don't have this document, they can't manage the retirement funds, which may be crucial to making sure the family's taken care of or you're taken care of. The other thing people often do is say, well, can't I just name my kids on the account or put them on title? Please don't do that. When you put somebody else on title with you for bank accounts, they now have ownership equal to yours. That's not often a good thing. The account is also now liable for their liabilities. If they are in a car accident, if they go through a divorce, your asset can now be looked at for those issues. Putting them on title of property. This can affect property taxes immediately. So unless they're living in that property, if you put them on title, it's going up instantly. It also can affect capital gains tax advantages in the future. So just adding people to accounts is not often what we recommend. Having this power of attorney that says, if I can't, this is the person or these are the people that are allowed, that is what we recommend to do. Now, the date that's important, there we go. The date that is important on the power of attorney. If it has not been done in the last 5 years, you need to have it updated. Banks have started rejecting durable powers of attorney that are 5 years or older because they are calling them stale. They're essentially saying it's outdated. We don't trust that the people you named 10 years ago really are still the people you want. In some cases, it's just red tape that's a pain. And in other cases, they actually reject it and we have to go to court. So check that 5 years. If you're not sure which one I'm talking about or you're not sure what the date is, again, bring it in and I'm happy to take a look at it. Now, part of why those are super crucial documents to have, if you become incapacitated and you did not have those in place, we unfortunately do have to go to court to get what is called a conservatorship. This is where the court gets to decide who has the power to take care of you or the money and the scope of that power, which in that time period can mean bills are lagging behind and becoming unpaid. You can't get doctor's appointments. You can't get medications refilled. You can't get the care that you actually need. You can't be moved to the facility level that you now need. These are all, unfortunately, very real examples of what happens when those first 2 documents are not in place or valid. So if you walk away with nothing else today, remember the healthcare and the power of attorney need to be done and need to be current. So the next question we're looking to answer is, do you need a will or do you need a trust? In California, wills are not often used because the parameters around them are very strict. So if you own a piece of property in California, essentially you need a trust. If you have just shy of $209,000, you actually need a trust. A will is only going to protect those who are under that threshold, because essentially what it says is if you're over that threshold and die with a will, you didn't answer enough questions to avoid the court. So that is where probate court comes in. That is the court that, if you only had a will, is going to decide who is your executor, so who's going to wrap everything up. They get to decide where the money goes and how it goes there. The control is 100% at that point with the court, which anytime that happens, it means, again, control's not with your family, but it also takes longer and frankly it costs more. So probate is one of those things that, again, we're talking about how to avoid it. The cost is something I really want to emphasize. One of the things you'll note on this slide is it says it costs 5 to 7% of the gross estate. So what that means is, let's say you have a property and it's worth $700,000. Woohoo! But you only have equity of $100,000. The court doesn't care. They're putting the percentage on the full 7. So regardless of equity, they're looking at the what could it be sold on the market for. So you can imagine if you have a mortgage, if you have car loans, you have things that needed to be paid off, and then you're in probate, how much it ends up eating into the estate rather than going to the people that you would want. The other issue is the time. I would argue that 18 to 24 months for probate is actually a lucky timeline. We have seen cases go 3 to 5 years, even in very simple circumstances. And that essentially means that no monies have been distributed and the estate is just stuck. We've had beneficiaries pass away while waiting for probate to wrap up. We've had family fights that get worse because that timeline is taking so long. So again, I won't keep scaring you, but I hope you're realizing probate is something you very much want to avoid. And then we have just a really quick chart on Copenbarger.com under the resources tab. There's actually a probate calculator. It's free. You can plug in what your estate would be to see what that scary number would be. One of the things you'll notice is at the top, attorney's fees. Why would an attorney be standing here and telling you to avoid probate when it looks like we could be paid a decent amount? Couple of things to note. We don't set our own fees in probate. They actually get to set our fees. So that amount, if you're working with a probate attorney, is dictated often by the court. But the other thing at Copenbarger is we very much believe we want things to be done that are in your best interest. And probate is not in your best interest. And so if you find an attorney who is not dissuading you from probate, probably run, because again, it is not in your best interest, and that is why we are here, to make sure you are actually protected and your family and your legacy are actually protected. So that's where the good news comes. We can avoid probate by using trusts. There we go. So one of the big advantages to using a trust is right there at the top, it avoids probate. With probate, with probate proceedings, they are public. With a trust, it can be kept private. So the only people who get to see your trust are those who are included in that document, which means the whole world doesn't get to know what you have and who your family is. It also allows for tax planning. Now, what I hear when I say this is often, we're not in the uber wealthy, so why would I need to worry about tax planning? Well, whether we like it or not, taxes are everywhere, and they affect us and our estates more than we probably realize. We're going to talk about a number of them today, but a big one is property tax protection. When you pass away, do you want the option of preserving your property taxes for future generations? If the answer is yes, well, that becomes part of what we can do in your estate plan. So again, there's a lot of different ways taxes affect us, no matter what our actual estate size is. And there are things that you can proactively do that cannot be done once you have passed away. But one of the big things to note, if you already have a trust, it only protects what it owns. So what does that actually mean? When you set up a trust, you should, generally speaking, put your real property into the name of the trust, your checking and savings accounts, and your non-retirement brokerage or investment accounts. The reason for this is the title is imperative to fully keeping the court away from your estate when you pass away. If you already have a trust and you have questions of, have I done this correctly, reach out to us and we can help walk you through how to double check. But if you forget, let's say you've got a checking account, it's got $300,000 in it, so it's over that probate threshold. You pass away and it's in your name alone, you have no beneficiaries, the trust is not mentioned anywhere. Ordinarily, the court would get to then control that asset in full, even though you have a trust. But what we have done, I'm going to skip one slide really quickly. What we have done is created with your trust what is called a pour-over will. The purpose of the pour-over will is to say, okay, whoops, I left an account out of my trust, but I still intended for everything to go to my trust. So court, thanks but no thanks, give it back to my trust and let that control. So it is a safety net. It's not the best option because we do still have to go and tell the court, get out of my estate, but it keeps it from going through the full probate experience. If you have a Copenbarger trust, you have a pour-over will. If you don't have a Copenbarger trust, I'm happy to take a look at your estate plan and see if you have this pour-over will. It's often a very short, very simple document, but it is a crucial component of making sure you or your estate are fully protected. I'm going to go back one slide, I apologize. One of the issues we often hear, though, from people who haven't started the estate planning journey or aren't sure how to update it is, I don't necessarily know who's going to manage when I'm gone. Yeah, I've got my kids, but I don't actually want them to be the ones to manage. Maybe they're not responsible. Maybe there's already been some fighting and you're worried that that won't get better after you're gone. And you're not then ready to take that leap because you're not sure how to answer that question. That is where we come in. We have different options, you're seeing two on this screen, of different ways we can help you answer those questions, different ideas that maybe you haven't thought about yet. So when you're stuck on I don't have the answer yet, so I'm just not gonna do it, I encourage you to at least come in and have these conversations because part of what we're here for is to help dialogue and see are there other alternatives that could answer the question so that you really can get that protection in place. So again, if that's speaking to you, come meet with us and we'll help you work through those issues. All right. So a lot of what we focus on are the dollars and cents. How much is your estate plan? What's in it? All of those pieces absolutely need to be addressed. But what about things that are more emotional? What about things that aren't actually tangible? Social media and digital accounts. A lot of people have them, and at this point, a lot of people have value in them. It could be photos, it could be memories. And when a person passes away, if there's no password left behind, those things become just gone. They just disappear at that point. So, now take this with however much caution you need. Writing down passwords can be valuable. Now, obviously, when you write a password down, there's a risk of somebody finding it. So I wouldn't write it down and leave it on your dining room table or attached to your fridge. You could put it in your safety deposit box. You could put it in your safe. You could put it on file even with us. It doesn't matter how, but I do encourage you, if you're writing passwords down, keep them in a secure location. But it can be very beneficial and helpful to the family to have those things after you are gone. Cryptocurrency, that is now becoming a huge issue. If you have cryptocurrency, this is probably old news. But if you were to die with cryptocurrency and did not have it in a traceable way, you didn't leave the key or the code or the chain or whatever it is that you have, that's the sequence of numbers or letters to access the asset. If you die and nobody has it, that value is often gone and unrecoverable. So if you do have cryptocurrency, you need to make sure it is, again, marked somewhere that somebody can find. Otherwise, when you pass, that asset is, in most cases, again, unrecoverable. What about, again, the intangible, completely intangible things that have more of an emotional value? How do you capture that? And are you even planning to capture that? A lot of people forget about their stuff. They forget about the memories that maybe a piece of furniture has or a ring has, and they don't capture that when they're thinking about their estate plan. What we encourage all of our clients to do is, especially for things that have family history or more of an emotional story, write it down somewhere. Because again, once you're gone or once future generations are gone, those stories start to disappear as well. So when we're talking estate planning, part of that is the legacy that's left that has to do with your stuff. The other thing we often hear from people is, well, my kids said they don't want it, throw it out, get rid of it. And if you've heard me speak on this before, you know how much I disagree with that sentiment. Because a lot of times what happens is your kids don't want anything when you're here, whether because you're here or because they feel kind of weird claiming stuff while you are still here. But what often happens is after our loved ones pass away, their stuff all of a sudden has a very different meaning and very, very different value. And some of the issue can be what happens when two people find the same value in one item. We have seen horrific fights break out after a loved one has died over the stuff. Some of our worst and frankly most expensive litigations and fights have had a lot to do with stuff. So here's a few things. One, again, write down why it has meaning, why it has value if you don't have the opportunity to tell them while you're still here with us. The second thing that you're able to do if you have a Copenbarger trust is use what is called a letter of instruction. This is a handwritten letter that you sign and date, but it says who an item is going to go to and then what that item is. That helps cut out the fighting over an item because that has the legal weight to say, when I'm gone, this ring is going to this specific person. You don't get to fight over it. And again, a lot of times that value isn't found for the person till you are gone. So the worst case is you left them an item that they really didn't want. Okay, fine. But in most cases, that item becomes, wow, mom wanted me to have this. Yeah, I'm holding on to this forever. And so again, yes, the dollars and cents are very important and we need to plan for them, but the emotional stuff, don't forget about it. And if you have questions on it, we are more than happy to help you. If in your binder you don't have a how to write that memorandum sheet that we normally put in with your estate plan, let me know. We can get one sent to you. We have it electronic, but it's how to actually use those memorandums. So again, don't hesitate on the stuff to remember how important it is. DIY estate plan. So if you already have a Copenbarger trust, you've avoided the do-it-yourself for the most part. But what we unfortunately see is after a trust has been set up, people go, oh, I just have a quick change. I'm just changing who the first person is, so I'm going to cross them off, just write in the new name. Okay, I'm going to very strongly request you do not do that. When you start to write on your own trust or try to do simple changes at home on your own, what unfortunately can happen is you can invalidate the section. You can lead to confusion and cause confusion that ends up in court. And in some cases, you can 100% invalidate the document. So before you start to write on your estate plan, call us. There are certain things our clients do have the ability to do and write in their trust. But if you're not confident we have given you the affirmative, give us a call before you do. The other issue is when you find things online that are free and cheap. I already somewhat mentioned this. Often what that means is that quality is being cut. And while estate planning on its face can seem very simple, I'm naming who I want to manage and where I want my stuff to go to. When it is too simple, what that means is if any issues arise that are not specifically then addressed in your trust, the only person who gets to decide it is the court and the judge. So you want something that is comprehensive. You want something that is complex because then we've gone through and said, okay, if this issue happened for one client, it's addressed for all of you. That way, if it comes up for you, we get to keep the court away from it as much as possible. So again, when you're looking, especially if you're going to be starting your estate planning, be very cautious when the price seems too good to be true or too much lower. There's often a very, very good reason they've been able to discount, or I should say a bad reason, they've been able to discount it that much. The other issue is don't just email me changes. One of the things that we do see is people, I've had a few clients, they email me and go, okay, this is effective immediately. No, it is not. Again, it needs to be done formally. So if you are planning to make changes, I know it can be a pain to find the time to come in and meet with us. Please do it. We love to see you. We'll try to make it as painless, as fun as possible, but it is very important to come in again because estate planning is not simple. And when someone dies, that is not when we want to find out that a corner was cut and now the family is having to go through the nightmare that is court once you're gone. Okay, so that is estate planning. So that is the foundation component. Now we're going to really focus, for those of you who already have a plan, why do you need to come in and see us every 3 to 5 years? Not just because you love spending the time with us, but because as life changes or the law changes, it is extremely important to make sure that that plan is being kept up to date. So life changes mean we need to look at your estate plan. All right. Did you have minors when you first set up your plan that are now adults? Do you have adult children that had no kids that now have kids? Are your beneficiaries still the same period? Did you have charities mentioned or siblings who may have passed away? Nieces and nephews maybe you're not as close with? Are you planning to move? That is becoming more and more common, that people are not wanting to stay in the wonderful state of California. They are leaving to other states. When people move, that often means assets are changing pretty drastically. Are you remembering to tell the new title company that you have a trust so that they put your property in this trust? Are you remembering when you move and you open a new bank account to tell them you have a trust? Or is that a step that you're forgetting about? So when you're going through these life stages, honestly, give us a call. The best case is we'll say there's nothing that you need to do. The second best case is we'll say there are things you need to do, and we get them addressed before there's an issue. Again, before you move, this is a huge piece. Make sure you remember anytime you're shifting assets. Doesn't matter if it may not be applicable, mention to the financial institution, hey, I've got a trust. Mention to that title company, hey, I've got a trust. Because often when they're asking you, how would you want to take title, they're not reminding you, do you have a trust? It's not often a noticeable, or in some cases even an option on those forms. So again, it's important that either you have to remember or give us a call so we can remind you. The good news is if you're moving out of California, it doesn't mean your trust is now obsolete. A lot of these documents can continue with you and continue protecting you. But other states may have different rules. So as you're moving, let us know and we'll see if we have a good referral for someone in that area who you can possibly meet with, just to give your plan a once over and make sure there's nothing in that state that needs to be done. If you have moved into California, which I bet is less likely for most, but if you have moved into California, it's the same thing. We need to make sure things are done correctly. So if you are new to the state, come in and see us. Another huge life change. Were you single when you set up your estate plan and now you're married? Were you married when you set up your estate plan and now you are separated? These are huge life changes that can very much drastically influence what is in your estate plan. For married couples, you have different options as far as protecting the estate after one of you passes. Some people don't want their spouse to have full control over the assets when they die. They say, hey, I love you and I want you to be able to use them. But if you get remarried, I really don't want you giving my half away to a new spouse. So we have what is called an AB trust that can preserve it for the marriage that existed when it was set up and allow the spouse, the survivor, to keep using all of the assets without changing half of the plan. So that is something, if you weren't married when you first set it up, or maybe you were in a different life circumstance, we can then talk about. What about if you got divorced? Well, very likely things like who's your healthcare agent, you probably don't want your ex-spouse to still be named as your medical power of attorney. I know I wouldn't. So with that, if you have gotten separated, we want to take a look at your estate to make sure at that point that the person that you're now separated from is not named throughout all of these documents, and that final step of the divorce has been taken. Again, it's just one more way that when life changes, you do need to give us a call. What if you had minor children that are now adults? That is another big area that we're able to start helping and protect. For one, your minors who are now adults, you might want them in the different roles. Maybe they should be your healthcare power of attorney. Maybe they should be the person who's your trustee. Maybe not, but it's at least worth the conversation. The other thing, though, becomes, okay, if I die and they inherit, they're now an adult with their own possible liabilities. So how do I make sure the inheritance can't be taken in the event they go through any of those liabilities? So we have what is called a protective living trust. What that is for the adult children. It says you still get your inheritance. You could even still be the manager if that's appropriate, but it can't then be taken away because it's being put in a trust. So that protects it from creditors, lawsuits, bankruptcy, even the IRS, and divorce. So even in California, where we are a community property state, it ensures then that when a divorce occurs, the inheritance cannot be considered as part of that divorce proceeding. It also ensures if your children pass and they have their own kids, that it would transfer down to your grandchildren. So it keeps it in a legacy, keeps it in a line for, again, multiple generations. This is not for everybody, but if you have questions on it, you're not sure if it's already in your plan, again, the moral of today is come and talk to us. What if you have a special needs beneficiary? Now I'm going to pause. You'll notice on the bottom of the screen there is a QR code. But what that essentially is flagging is that we've done a webinar that goes into even more depth on this topic. The reason we do these is a lot of times we're going very quickly over these topics, but if you have a special needs beneficiary, you probably want more information. So you can scan the QR code and it will take you to that webinar. It's free. Watch it as much or as little as you want. One of the big things, though, when people have special needs beneficiaries, and this is somebody who's on government benefits for a disability reason, they just assume they cannot leave an inheritance to that person, period. So either that person is left out completely, or what we see is they'll say, oh, I'll give it to their sibling, and their sibling will use it to take care of them. We've seen that not happen. We have unfortunately had many cases where, especially where the sibling was left in charge, that money is now legally the siblings. They are under no obligation to take care of their sibling using that money. And do you think they do? Not often. So what we can do is set up a special needs or supplemental needs trust. What it's essentially doing is housing the inheritance and saying, if the government benefits won't cover the scope of their need, this inheritance being held there can be. Someone else does need to manage it, but it allows you to leave an inheritance without costing them their benefits and without risking it going to somebody who may not actually use it for the intent that you wanted. So again, if you have more questions, use the QR code, or again, come and see us. But we do a ton when it comes to life planning. So if you have pets, that is a huge thing for me. If you are an animal lover like I am, we can provide for your pets. If you have firearms, especially in California, we can help provide provisions for firearms. If you have rental properties, if you want to help plan for your grandchildren's education or great-grandchildren's education or nieces and nephews' education, again, the moral is we can help and come and talk to us. So no matter how complex or how simple you fall into that realm, odds are we can get a very comprehensive plan set up for you. I mentioned this earlier. An email is not enough. I won't harp on that again. But it is very important when you have a change to make sure it is done correctly so that you don't risk either not having the change you wanted or causing larger issues down the line. Okay, legal changes. Everybody take a big breath as we move into the third section. Legal changes have been a huge part of what we have to talk about in the last 5 years. Since, actually, more than that, since 2019, things have been changing extremely quickly. I don't know if it was just because of COVID or why that 2020 mark really set a lot in motion, but especially if you have not seen us since 2019, odds are your estate plan needs some legal changes or at least to discuss them. Because again, there were a lot. So these are the ones that we are going to go over today. I'm going to cover the first chunk and then Catherine is going to cover the second chunk. How many of you at this point have heard about Proposition 19? Okay, more hands, but still not as many hands as we would like. So we're going to keep talking about it until it's the entire room saying they know what this thing is. The old rules got obliterated by Prop 19 when it came to a child or anybody inheriting a piece of property and whether or not the property taxes could be preserved. Again, you'll see a QR code. That means we have definitely done a webinar on this topic. What Prop 19 has now done is it says if you have any secondary property, rental in California, rental, business property, land, and it transfers when you die, the property taxes are going up, period. The only exception to this is if you are planning to purchase a secondary property, so not one you currently own. There are options using LLCs that can help preserve them in the future. But again, it is not applicable to things already owned. It is only applicable to secondary properties to be purchased. The only other exception is your primary residence. But again, that had very strict requirements. It needed to be your primary residence when you died, and the child it's transferring to, because it's only applicable to children, also has to keep it as their primary residence indefinitely. They keep it for 5 years and then turn it into a rental, the property tax is going up at that point. Why this is so important and why this requires, in some cases, specific language. If you have more than one child, if you're like me and an only child, it's a moot issue. But if you have siblings, if your parents left you the estate and your siblings equally, and the property goes out to you guys, and then you say, well, hey, I'd like to live in it, can I buy you guys out? And they say, sure, we'd rather have the cash. The portions they now transfer to you get reassessed, because that is a now child-to-child transfer. But if mom and dad had put language in the trust that said, hey, you're likely the one who wants to own it, so you're the one who gets to buy them out before any distributions actually occurred, now it's still a parent-to-child transfer. They walk away with an equal portion of cash, you walk away with the property, and assuming you live in it, you keep that full property tax base, or at least very close to it. There's a calculation that they do still limit what that transfer can be. This is very complicated, and I'm not going in, obviously, to very specific detail. This is very, very vague. But if you're not sure if you already have the right of first refusal, or you're not sure if you need it, the keys to look for it: do you have more than one child? Do you have a primary residence? And do you want the possibility of keeping your property taxes as close to what you pay as possible for that future generation? If you're answering yes to those questions, come in and see us, and either let's make sure you have the language or debate whether or not you really do need it. But that, again, is one of the only ways, unfortunately now, to preserve property taxes for property. As I mentioned, using an LLC is an option, so that's where Catherine steps in. So if you are planning to purchase a property, before you buy it, come and speak with her to see, does an LLC make more sense? The reason LLCs can work is when you die, instead of a property changing hands and changing title, the corporation is changing hands. That means the property never changed title, which is why the property tax trigger doesn't come into play. But again, really need to hammer this home. It is only before you have bought that property. So if you are in process or will be soon, get a meeting with her as soon as possible. Another huge one that has been changing pretty drastically over the last 3 years has to do with Medi-Cal. The reason we bring up Medi-Cal, no matter what audience we are in front of, is because a lot of people don't realize how many options they have when it comes to planning after you have become sick and need assisted living, skilled nursing, or advanced in-home care. The reason we bring this up everywhere is it's because becoming ill and losing control is consistently a very top concern for seniors. And it's often a top concern for the person who is going to be in the caregiving position. And so we want to make sure you have as much information as possible so that you understand what options really are available. One of the issues when you become sick, and this may be a bit preaching to the choir, is unfortunately medical costs are often much greater than they are when you're healthy. That could be because doctors and nurses' prescriptions, you just need more involvement from your medical team. But a lot of times what's kicking in is, are you able to stay home? Are you able to stay home without care? Or do you now need to move into a facility? And unfortunately, those facilities cost a ton. And most people are not in a position to pay using their own resources or even using their family resources. Some people have long-term care insurance, but unfortunately what we have found is the insurance is not keeping up with the price and the length of time people need it. It may supplement, but a lot of times, again, when you're looking at a $20,000 bill per month and it will only cover 10, you've still got to figure out how to come up with that other 10. And the 20,000 number is, unfortunately for some of these tiers, not outside the realm of reality, especially living in the state that we do. So a lot of people don't realize Medi-Cal is actually something they could consider. Now, for those of you who don't know, Medi-Cal is not age-based, it is needs-based. It is needs-based as far as, do you physically or mentally need it? And then do you need it as far as your assets? So let's get into that piece of it. Medi-Cal is a very complex thing. So what has been going on? Years ago now, I'll say about 5 years, and then historically, Medi-Cal said if you had your primary residence, you were fine, but if you had more than $2,000, you were wealthy. Okay, I would debate anyone in California who only has $2,000 is not wealthy. Okay, so then, again, about now 4 years ago, they said, all right, we're gonna raise that number to $130,000. So if you had your primary residence and $130,000 of non-exempt assets, so this didn't include retirement, all right, now you could qualify. That was a huge leap, and so it opened the door for people who beforehand couldn't have qualified, period. Then they changed in 2025. They said, well, you know what? We're gonna get rid of the asset test. We're now gonna look at people's income. Okay, so we switched our entire planning strategy, and I'll get into what those strategies are, to focus on what are our clients' income and can we protect it. That lasted half a year before Medi-Cal said, and California said, that opened the door too much, we're going to go broke. So just kidding, everybody, we're going back to assets. So, a couple of things here. If you qualified for Medi-Cal under the income standard, most people are being grandfathered in now that they're back to the asset standard. And vice versa. If you had been qualified under the asset standard, got grandfathered into the income, you're grandfathered continuing into the assets again. So if you're already on Medi-Cal, you may not need to listen to much of what I'm going to say. But for a lot of people, this has gotten very confusing. It's okay, what needs to be protected? How do I protect it? What the heck is the state doing? The reason we bring this up, we don't do Medi-Cal qualifications specifically. We do work with someone who does. So if you need assistance, let us know. But the reason this is important for Copenbarger is we actually have what is called a Medi-Cal Asset Protection Trust. What that trust is designed to do is protect the assets from Medi-Cal, using them to disqualify you if you are over that threshold. The reason that we did this is Lloyd had clients years ago now, more than a decade and a half, who were a married couple where the husband had Alzheimer's and was going to need pretty advanced care, not memory care, but advanced long-term skilled nursing. They had a reasonable estate. We didn't have this trust in existence at that time, and we really didn't think it was needed because for Lloyd and a lot of people, it was if you have the money, don't use the government program. But what ended up happening with this couple is because of the cost of long-term skilled nursing, that very reasonable estate disappeared while the wife took care of him. And after the husband died, the wife came back into Lloyd and he found that she was just shy of destitute. She'd had to sell her house, she was moving back in with the kids, she had nothing. And it broke Lloyd's heart. And he said that's not a choice someone should have to make between giving their loved one the care they need and preserving enough to take care of themselves for their lifetime. And so he fervently jumped into the Medi-Cal rules and said there have to be loopholes, there have to be back doors, there's got to be something here that we can protect our clients from ending up in that situation. And what he found is there are. And so we created this Medi-Cal trust, which Medi-Cal of course challenged and has upheld now for more than a decade, but again houses the non-exempt assets that Medi-Cal could have looked at and says, nope, keep your hands away from that. For those of you questioning, well, again, if I have resources, why should I use the government? Couple of issues. Again, the government hasn't regulated the cost of that care, and so most people can't afford it. It's just not a realistic option. And so, very bluntly, if you can't afford it, you should also then be able to use a program, and this is the second reason, that you paid into every time you paid taxes. It is a program that we do believe should be used if or when that is needed. This is not a trust for everybody. It is an irrevocable trust, which comes with different restrictions than your revocable trust has. However, If you or a loved one is in a position where in-home support services may be needed, or the skilled nursing facility, sorry, blanked on the name completely. The skilled nursing facility is needed. Come in and speak with us. For some people, we do this as very pre-planning. For others, we often are planning when we're concerned the need may be coming in the next 6 months to a year. We can do emergent planning. So for some people, we're in emergent planning. They've already been diagnosed, they have lost the competency to sign a trust. We know that they're going into a skilled nursing facility, and we need this now. But the problem with emergent planning is we can only do it if your power of attorney allows and your trust allows. So again, if you have not seen us in the last 5 years, you need to come in and see us so we can make sure if an emergency came up, that your trust and the power of attorney would allow your loved ones to set that planning up on your behalf. There is no QR code, but I did recently do a Medi-Cal webinar that goes into this topic much more in depth and just focuses on that topic. So if you have more questions on that, not only can you come and meet with me, but feel free to, on our YouTube channel, find that Medi-Cal webinar. It was done within just the last month and a half. So feel free to watch it if you have more questions on this trust. All right, you'll see a couple slides in here. I'm not going to go over them a ton. It's just the different thresholds that you need to be concerned about. If you're single versus if you are married, it is a different threshold number. It's also different if you have other people living in your house as dependents. So even if you have adult children, if they're still living in home, they can actually go into the additional $65,000 number that bumps the amount of money you can have before Medi-Cal. One moment. Before Medi-Cal would say you don't qualify. So just be aware of that. That as well.
Yeah.
Just throw it. Might work. I mentioned before, we work with a Medi-Cal qualification person. So if you've ever been through trying to qualify for a government program, it's a pain. It is not easy. They are not designed to help you qualify. I went through this years ago for my dad with disability. And believe me, they are not trying to assist you in getting onto these programs. If you have somebody who can help you, that's wonderful. But if you're in the position, which a lot of people are, where they don't have someone either who can or has the time or just period doesn't have someone that is able, come and see us because again, we can help connect you with someone who is able to. This is something that you want done right if possible the first time because again, having gone through an appeals process, that is a pain in the rear. So getting it right the first time can very much cut stress, make sure you get the program you need quicker, make sure you get the care you need quicker, and again, it makes a fundamental difference. So if you're in that position or you know someone who is, again, you'll hear me say this 15 times at least today, come and see us. All right. Another one that changed in the last 5-6 years has to do with your retirement planning. So I'm not going to talk on the financial advising side. I leave that to my husband who you've seen. Oh, there he is. He just walked in. That was great timing. I leave the retirement financial planning stuff to him. It's wonderful. You ask me a question I don't know and I say, talk to him. But this does affect your estate plan. So what is the Secure Act? The Secure Act is a rule that says for retirement accounts that are inherited by just about, well, by anyone except this exceptions list, they now only have 10 years to draw down the portion they inherit. On a financial advising side, this can drastically change how you structure your wealth to make sure taxes don't hit any more than absolutely necessary. The reason it's applicable on my end, remember when I mentioned those protective lifetime trusts? Those are the trusts for adult children that protected the inheritance from divorce and lawsuits and creditors and bankruptcy and the IRS. A lot of people want their retirement accounts to also get that protection when the kids inherit. So they name the trust as the beneficiary. But the only way that can happen without causing a huge tax issue is if the retirement section in your trust complies with that new rule. If you have a trust done from 2021 or later, that language is in there. If you've done what we've called our Secure Act amendment, where we've updated that, you're clear. But if you're not sure, you have not seen us, and you have those protective trusts, or you're not sure if you do, again, I'll say it again, come in and see us. Because for those who flow the retirement through the trust without the proper language, it can mean that that account doesn't even have 10 years, it's taxed once, which is a much larger tax than if it can be spread out. But again, you can still use the rule if the language is correct. So come and see us. It's relatively quick for us to verify whether or not you do have that language. If you don't, we can then talk about what is that going to entail. Again, QR code, we've done a webinar on this topic, so if you have more questions about retirement accounts and how they connect with your estate plan, again, definitely come in and see us or watch the webinar. So with that, I am now going to bring up Zachary Raymond. So as I mentioned, this is actually my husband. So Lifestyle Financial was started by Laura Copenbarger, who is the wife of our founder, Lloyd Copenbarger. She started her company many, many years ago. I won't age her, so I won't say how many, but she eventually did want to retire and enjoy the grandbabies and the great-grandbabies. And so her grandson, Charles, actually took over Lifestyle Financial. Zachary came from somewhere I won't mention, it's his joke to say, but he came from somewhere that was not as family-centric, and it was a problem. Because he very much wants to make sure that families are protected. We're raising our child, we want to make sure that young families and our friends and our future generations have that protection. And that is what Lifestyle does. They focus on families, which is very much near and dear to what Copenbarger does. So with that, I'm going to bring him up and you get to hear from him. Thank you, guys.
Good morning, everybody. Can you all hear me okay? Okay, that's good, because I talk a lot and sometimes I get really excited and I talk very loud. For those of you who don't know me, I'm Zach. I'm Vicky's husband. And if you saw the cutest little almost 2-year-old in pink, that is my daughter Emma. Some of you might know her by reputation. Some of you have become a new friend of hers. Hi, Phoebe. And there will be a quiz about my daughter later. I'm half joking. Show of hands. Who has more than $5? Great, everybody should talk to me. See, it almost cut out during my first joke. Hello? This is gonna be fun.
Get used to it.
Oh, perfect. I like it. I like curveballs. So, a little bit about Lifestyle Financial. This is not gonna work. Can you guys all hear me okay? Yeah. Cool. That's also not gonna work. So, Vicky had said I came from a different firm. Has anybody heard of a small firm called Merrill Lynch? Yes. Yeah. Formerly, or currently now, Bank of America Finance, and we do not talk about this. I recently saw a movie called Encanto. We don't talk about Bruno. I don't talk about that. But if you want an off-the-cuff story about Merrill Lynch, that is where I cut my teeth, as they say. Yes, I was in a bullpen, and it was a wonderful training experience. You know, all the big firms, I try to never be rude or offensive about anyone in the business because it is a whole establishment that should build trust with every single person who wants to have the courage to get uncomfortable and talk about money with a complete stranger. I'm not dangerous, I'm not mean, but you don't know me that well, and I would love for you guys to know me, and I want to earn the trust to talk about money, because money, everybody has to deal with it, and it kind of makes people crazy sometimes. That is a financial term. I'll show you where it is in the financial dictionary right next to volatility, interest rates, inflation. Everybody's favorite couple of words over the last couple of years, right? A little bit about Lifestyle Financial. Victoria was kind enough to not age us, but we are now 32 years young. Laura Copenbarger had a great idea about trying to help people. Her grandson Charles Sosa and I got a chance to know each other when I was still at that former firm. We professionally dated for about a year before we both made the decision to work together, because we had to establish that same standard of trust with each other, so that whenever someone talks to us, you get to talk to both of us at the same time. We don't pick and choose talking to a client or a situation, because all of you are unique. You all have different perspectives. You will like to have this committee approach where it's not just my mind or Charles's mind. It's both of our minds looking at everything that touches your financial well-being. So, let's get started. What does Lifestyle Financial deal with? Everything that touches money. It's a very nice, easy answer. We talk a lot about not just the liquid or stock and bond side of your financial picture, but the illiquid, such as real estate. Especially in the state of California, real estate tends to be the largest financial component for most people. Not everyone, but usually. And so our job is to allocate this 360-degree picture, the total picture of your financial well-being, and give you honest feedback. Sometimes people might have questions. Lately that it's on my mind because Emma's about to turn 2, I've been thinking a lot about 529 accounts. Show of hands, who has kids, grandkids, nieces, nephews, little ones that you like and would like to see go through college? You don't have to raise your hands, but it's always appreciated. Or if you have an IRA or a 401k or a 403b or any other type of defined contribution or defined benefit plan, DB or DC plan. Show of hands that you want to make sure that your beneficiaries are properly titled. You just spent a lot of time listening to my wife talk about the structures, the 4 walls of a legal document to protect you guys. That is essential. Uncompromising, because you're going to be dealing with my wife, so you have to. But in order to make sure that everything flows as essentially necessary and properly as you want it to, you also want to find a trusted financial sounding board. You don't have to, but I recommend that you do. Obviously, because you get to talk to me. But it's not one size fits all. It's a pick and choose, and you have an individual story, and every plan's going to be different. I don't think any of you guys are clones of each other, so you all have a different financial perspective. Some of you on your own, some of you as a couple, some of you as a representative for your entire family. And maybe some of you want to give to charity or your church or something you believe in as a cause. That's part of the financial plan as much as it goes in your estate plan. Has anybody been listening to the news about the financial markets lately? So, let's see, a couple of vocabulary words. I already threw out the fun ones. Anybody aware of the prices of the gas pump due to certain things that are happening around the world? Yeah. There is still a conflict in Eastern Europe. It did not go away. We recently had a summit with our biggest frenemies, or the It's Complicated relationship, as I call it, China. All of that is happening around the world, and at the same time, the investment landscape is getting smaller and smaller because we're all more interconnected. Little show of hands. Who has used, heard of, or witnessed firsthand ChatGPT? Yeah. Or Anthropic, or anything regarding AI. That is a huge new innovation cycle. That's a very fancy term that finance people are saying there's a lot of money being thrown into it. There's a balance of understanding where change is happening, because change is inevitable, but not necessarily running away or towards it, having a balanced approach and perspective. That's where financial planning comes into play. It's not necessarily about just picking and choosing the single direction you're supposed to go, but understanding all the possible outflows that could happen. And for each individual or family situation, it's different. It should be, because you're all going through different stages of life. Everybody here is going to have financial decisions to make today, knock on wood, tomorrow also. So we might as well have a plan for it, short, medium, and long term. I think that one of the biggest values that people can understand is you don't just get rewarded for the perfect timing. I don't know about you guys, but I am a terrible gambler. I don't do it. My day job has a lot of things that we call unknowns. So the whole idea of financial planning is to get as many of the unknowns off of the table to the known category. What is inflation going to look like? I can't tell you what it's going to look like next month, but I can narrow down the field and give you a range of the outcomes that are most likely to happen, and you can plan for that. And that removes some of the risk off the table. In this business, the only certainty is uncertainty. If you've had a meeting with me in the past, I like to rhyme, because history does not repeat itself in the financial markets, but it does tend to rhyme a lot. I don't think my gray hair is showing yet. Emma hasn't done that to me, but history has shown us, if you can remember, inflation didn't just sprout up a couple years ago. It's been here for decades, ebbing and flowing. There's a natural basis for the change of the value of the dollar. That's basically an inflation principle. Those are about as big the words as I like to use, not because you don't want to hear big words, but it doesn't serve you any value. Lifestyle Financial takes great pride in trying to educate everyone who meets with us. My wife tends to say sometimes I would have been a great third grade teacher. I think it's because of all the little toys third graders get to play with, and I like trying to like build train sets and everything. It's a lot of fun, but it's more important because when you're trying to educate people or come up with a whole plan of financial planning for the next 40 years, you need to break it down to something that's easily understandable. Who here is a little nervous about the stock market? Who has no concerns whatsoever? I like this guy. The truth is somewhere in between. Probably the greatest equivalent to a legal answer I'll give you, it depends. The reality is there is a lot of fundamentally good things happening in the stock market. And the stock market, when I mention it, just to be clear, I figure first in the US stock market, but then you also look at it as a global stock market because it all balances together. And then you have the stock part of this, the actual stocks in the stock market, and you have the bond part of this. Or for some people, maybe you have the cash part of this. And that could be in a bank, in a CD, money under the rug. I don't recommend that, usually because if you're like me, you have dogs and they find it and eat it. It was only $5 though, so it hit the threshold. It's painful. All of this is coming to a head because the biggest change that I would recommend to people to understand is it's not that things are easier or harder to invest nowadays, it's the rate of information we all get. How many of you have a cell phone? How many of you look at it every day? Yeah. And there's that wonderful internet browser for most cell phones that people have now. So you're gonna get information quicker, and it's gonna be a difficulty to balance what is fact from fiction. Part of that just depends on what the article is you're reading. This week I had a conversation, someone says oil's going to drop. And then the same day I had a conversation, someone said oil's gonna double in price. I'm like, why are you thinking about that? Well, this article told me so. That doesn't mean either one in its own is right or wrong for the thinking, but it has to be balanced with fact from fiction. We don't have the luxury in finance to not look at something just because it might be a political conversation or a part of the world conversation, because it all impacts finances. So you owe it to yourself whenever you talk to someone in this field to look at the whole picture. And then ask us the most uncomfortable questions. I love it because it allows us to demonstrate our skill set in this business. And then we get the opportunity, because you asked us a question, we'll ask you a question. How much are you invested over here? What do you think about your finances in 20 years? Are you ready for your young one to go to college? And then on fainted breath, I'm just terrified when she goes to middle school and starts dating and all the crazy things happen. But it's all part of the process because time doesn't have a pause button. It keeps on moving through life. When you try to schedule something, you blink and 5 years go by. So you want to have that plan in place now, and then you owe it to yourself to follow through on it. And sometimes along the way, just you have a great estate planning attorney support at Copenbarger, you need a financial planning team to give you that same sort of support. Be proactive. Some of you I do know, I do talk a lot, but I'm not necessarily intentionally trying to be nosy. I want to follow up with you because it's my job and duty. You owe it to yourselves to have someone to follow up with you for your financial well-being. Does that make sense? I see the laughter. That means that my wife also agrees with me. What we try to do, as I had said, is be an education firm. What does that mean? Well, we don't actually give you pop quizzes when you come into the office. We have a free newsletter, and we actually do our own writing for articles. It's one of the things that, again, I said earlier, be different without being offensive. Many firms have great research. How do I know that? I read most of it. You compliment people where they are right, and then you add to it where they might not cover something. So we try to add a little bit more of individual flavor or an understanding. A big thing right now is understanding how the moving growth of the stock market can be rationalized. Things have moved so fast in a very short period of time. It might naturally make people want to hit the pause button. But you shouldn't just do that because the market is not going to pause just because you're pausing. So you need to keep things moving. You need to keep things fluid. And you need a sounding board that will constantly give you that feedback. I will tell you if I don't think something is a good idea, okay? I am not here to be your friend. I would like to be everybody's friend. And those of you who have met me probably can tell everybody else here, I am a very friendly person most of the time. But what you want is the objective sounding board that I've been mentioning. Someone who will give you candid feedback. The difficult conversations are when we shut the door and we have an office meeting or a Zoom call or a phone call, that you know that whatever Zach or Charles says is the best advice we can give based off of your specific circumstances. That is uncompromising. I look at everybody here and I say, okay, if I am related to you, if this is my wife's future financially, I owe it to all of you to make the best decision, okay? Whether or not the day is good or bad. So, if you would like to schedule a meeting, please come see me outside. It's very nice and sunny outside, so you'll see me bright and shiny. Also, if you want, any meeting comes accompanied with a dog. I think I have 10 seconds, so one question before I bring Victoria up. Who is going to be the incoming chairman of the Federal Reserve? And if the first question is, what is the Federal Reserve? I will answer that outside. Anybody knows? Raise your hand. First one to answer correctly, I'll give a prize outside. No, but close. Walsh. Yes, who said that? Yeah. Kevin. Yeah. Yeah. Okay. Come see me outside. Without further ado, I'll bring it back to Victoria. Thank you.
Throw it. Thank you. We're going to try to get the mic back working. All right. Don't believe Zach when he says he's not here to be your friend. He'll be friends with all of you, but he will also give you great advice. So definitely, if you have questions, feel free to, yes, schedule a consultation. While we're getting this mic hopefully working, how many of you have heard about PJI? A number of you. All right. So one of the things when we talk estate planning is often, what if I want to leave things not just to my kids? What if I want charity involved? Who can that be? So PJI has been around for a number of years and has worked with Lloyd very closely. And so Mark, actually, you live in Sacramento, correct? Yes. So he's actually a local, so he knows the area. But we're going to bring up Mark to talk a little bit about PJI, what they do, and the work that they focus on. All right. And he has hopefully a working mic for the duration of his, although it already cut out on me. All right. So here is Mark.
Thank you, Victoria. Thank you so much, Victoria. Thank you. Appreciate the opportunity to be here. And I would just say this, I'm keeping paperwork in front of me because they've given me no more than 90 minutes. We promised to get you home by 3 p.m., so we're going to keep that promise. These guys are great. I just want to say this, you guys are in the right place, and I know you know that. We've been Copenbarger clients for, my wife and I, for nearly 20 years. I've had to serve as an executor 3 times with 3 different estates. It's fun. It's kind of like taking an ice pick and putting it in your ear, but they have made it as painless as it can possibly be, walking through every step of the process with us, keeping us out of probate, minimizing time, minimizing expenses, and it's really been great. So you guys know you're in the right place. I want to talk to you just for a bit about Pacific Justice Institute. We're here as Copenbarger clients, myself and Brad Dacus, our founder included, because we want to protect our estates, our families, etc. And Pacific Justice Institute similarly is in the business of protecting stuff, protecting your God-given liberty and rights. And before we get into this, I want to say something hopefully that's relevant to you. I don't know, how many of you have a fire extinguisher in your home? Anybody? Fire blanket? Okay, they're talking about fire blankets now. Just throw it over the stove and puts everything out. You hope you never have to use it, but it's really good to know that it's there and know where it is. So that's kind of how Pacific Justice Institute is. How many of you have heard the words free attorney in one sentence? Okay, so that's what we do. We have 130 cases in active litigation, and this is religious and civil liberty issues. I'm going to give you some clear specifics, but I want to ask you this. How many of you feel, particularly over the past generation, that your God-given rights and liberties, say life, marriage, family stuff, healthcare choices are coming under attack. How many of you feel that there is an attack on your God-given liberty, etc.? Okay, well, I'd say we feel this too, and I want to give you some examples of specific things that we're working on, so you really get a feel for what we're doing. But the mission of Pacific Justice Institute is to provide free legal representation for you or for people who have need at the grassroots level. Now, there are a lot of organizations out there, and they do great work. Christian and other nonprofit Christian or legal organizations, they will typically shoot for the Supreme Court cases because that's got more PR value. Okay, but we work at the local level, and I want to give you some examples. Okay, and we do it all for free. Everything's free. Okay, so imagine that your employer, you've been working for a company for a number of years, and they tell you, hey, you're doing a great job, but you have to get the vax to stay employed here. Has anybody known anybody where that's happened to them? Okay, now, I would just say this, we're not pro-vax or anti-vax, but we're about you should have that choice to make up that decision on your own. So we'll defend those freely. By the way, no one else, no other legal organization we know of was defending people in the area of COVID vax. Second thing, okay, imagine that you're a public school teacher and that you're told, both my parents were public school teachers, I've taught school also, but I want you to imagine that you are told by your administrator that there are going to be certain indoctrinations happening within the classroom, and the kids are going to be taught certain things, LGBT, whatever it is, and that there may be a cross-dressing and the use of pronouns and different things, and that you have to keep this hidden from the parents. I mean, how would you feel about that? Would you be comfortable doing that? Because we'll defend that freely, that you should be able to use the proper pronouns, and you should be able to operate according to the dictates of your own conscience. Okay, another one. I'm going to give you a one-sentence thing here and a clue, and I want to ask you to tell me the rest of the story. I know you'll be able to do that. Okay, I want you to imagine that you own it's a private Christian Korean bathhouse, women-only spa in Seattle. What happened next? Okay, you guys know. So a guy wanted to come in. They even tried to give accommodation. They said, if you had an alteration of procedure, he said, no, I just want to come in. I'm Mark, but I feel like Marlene. I'm coming in. So we're defending that, and please pray with us. It's called Olympus Spa, and it's for women and their daughters to be in partial or full undress without men coming in. That's what the case is about. We're praying that that'll go to the Supreme Court. So we're defending that freely. Okay, last thing I'll give you here is imagine that you're going to, how many of you have social media? You put something up. Okay, maybe not a lot, but you do. Okay, so let's say that you love your church or your synagogue. So you say, we love B'nai B'rith, we love Calvary Chapel. You just put that up, just very simple. We love our church, we love our synagogue. And a social worker sees that. Let's say you have school-age children, and they say, we need to come and investigate you because you could be intolerant. You could be, the legal terms are neglectful and abusive in your home because you have a biblical worldview and you're not allowing your children to hear all about LGBT. So they come and then they're going to threaten to take the kids out of the home. Now, people think this can't happen. It's happened. It happened in California, happened in Idaho. But we want you to know about the resource of Pacific Justice Institute. So if anything like that ever happens, or you know anybody where they're threatening to take the kids, we got to be involved before they get the kids, because they'll take them, they'll put them in foster care. You won't know where they are, and then the burden of proof is on you with doctors and psychologists to show your home is safe, etc. Anyway, am I dropping out a little bit? Anyway, so these resources are free, and when you have a problem like these, you call us. And how many of you know Brad Dacus? Anybody know Brad Dacus? You guys have seen him talk or heard him come. He comes to churches, he comes to synagogues, he's on the air all the time. He's handling all kinds of cases. But his goal, I think that I'm kind of coming in and out, right? A little bit? Yeah? Hello?
We can handle it.
Yeah? Okay. Well, I think maybe it's better if I just go like this. I don't project. But I just wanted to say this, that Brad's goal, we work for an organization that worked mainly on Supreme Court cases. We have 3 cases that may go to the Supreme Court this year. 130 cases in active litigation, and at the height of COVID, we had 270 cases in active litigation, all handled free to protect local people. But the goal was to protect the common person from being run over by a corporation. So we had like BART, Bay Area Rapid Transit, one of our favorite places to sue, and they said that people who worked for BART could no longer work there if they didn't get the vax. And a lot of people said, that's personal opinion, they're not comfortable getting the vax. So that ended up going to trial, and there was a pretty big settlement. We don't get any of that settlement, but it worked out. People had jobs restored in a big settlement. It's going to be appealed. BART's going to try to appeal that. My wife and I have 4 kids. They're college age, college and grad school age. They were all told during the COVID, you cannot go to school unless you get the vax. And we worked with PJI. We got some exemption letters written, and all of them could go to school according to the dictates of their conscience, didn't have to get the vax. So I want to give you guys some resources here. What we want to do is provide you resource. The website is PJI.org, stands for Pacific Justice Institute. There's great resources. If you ever want to hear encouraging stuff, things that are really cool and fun and legal and judicial progress across the country, you want to go and tune in Brad and hear him talk. But most importantly for me is the free resources to help you protect faith in the workplace, sharing your faith in the workplace, what you can do in schools, etc. Your liberty, protecting your own God-given liberties and rights. There's a lot of free, all of it, free resources. But then there's a Get Help button, pji.org, Get Help, drop down, and then it'll say Request Legal Review. So you say, here's the deal. Can we get your help? Could you guys look at this case? And a lot of the times on religious and civil liberty cases, we are there to help you. So I would say this in closing. In closing, I would say, please come and see me. I'd love to talk with you. I'd love to answer any questions. I'm right outside. Outside, right? Is that okay? Right outside here. It's shaded. Okay, it's beautiful day. It's shaded out there. But I want to say this: you're here to protect a state, family, your assets, etc. What would that be worth if you lose your liberty? That's what we're in the business of doing. We're in the business of fighting for your God-given liberty and rights, and then doing proactive things to preserve those too. So it's not just putting out dumpster fires. It's also doing proactive things to help get good leadership elected who are putting good law to bless you and your family and protect you. So anyway, I just want to say thank you very much. Come see us, and we're here to serve you freely.
Thank you.
It was kind of going in and out.
Okay.
I was just going to say this. There's a card in your packet, looks like this, but if you guys could fill that out, it's just information. We send a 1 page per month, 1 page front and back of good news, of stuff that you don't get to hear, of legal and judicial progress across the country. Just this one sheet, the top half, which is a quarter of a page. Anyway, thank you.
Thank you.
Thank you so much, Victoria.
All right. Thank you, Mark. I'm going to try to use the mic. I don't yell quite as much, and I won't try to keep you guys engaged doing that. Hopefully you're almost ready for a break, but before we go on break, we're going to go over one other thing, and that is our Access Member Program. So how many people in here are Access members? Do you mind raising your hands? Love it. This is a very full room of Access members. So what is the Access Membership Program? Before, I might have to yell. What is the Access Membership Program? So the Access Membership Program was started by Lloyd, probably more now than 30 years ago. And it was because as he was helping serve clients, one of the things that kept coming up is, what happens if I have a simple question? Am I going to get charged? Come on. Am I going to get charged? And very bluntly, a lot of times when you reach out to an attorney, there is a cost. And Lloyd realized, well, most people don't have an attorney sitting around the dining room table with them that they can, for free, get questions answered. And so he started this Access Membership Program. What this program has been designed to do is, it's right in the name. It has been designed to give people further access to us without, every time they've needed us, having a bill associated with that need. And so it's been a program that has actually been unchanged since its inception. And one of the things that we realized very recently in looking it over is, well, the firm has changed, but the benefits haven't. The cost has changed, but the benefits haven't. And so we took a very comprehensive look and said, where is the firm at today, and what does this program need to become and build more into? And so we have changed it pretty fundamentally. For those of you who are current Access members, you'll notice now when you look at the Access membership, instead of there being one tier that only applies to estate planning, there are 3 different tiers. The foundation tier is what our Access members are automatically placed in. That foundation tier has your same benefits, just greater benefits. So your annual credit that if you make changes went up. It is now transferable to your children when you pass away for a lower fee. That was never an option before. It was your program membership, and when you passed, that was it. You can also now add your children to your membership during your lifetime for a 50% discount. So again, instead of them needing to buy their own at full price, you can add them to your membership for a discounted price. So for current Access members, you not only are keeping benefits, but you're getting more benefits. For anyone who's not an Access member, why the Access membership program again has been so valuable is when clients have needed us, especially in emergent situations, we are able to go and visit them at the hospital and do any documentation then needed on site for free. So rather than what normally happens, which is if we get a call that, hey, I need a hospital or a home visit, we have to charge our hourly rate for that travel time, our Access members have that included in the membership they initially signed up for. So when you're going through those, a lot of times emergent situations, it is a weight off that you are able to have your attorney show up without again incurring that cost. So again, current Access members, you've got more benefits for no additional price. For, again, people who aren't, I mentioned that there are now 3 tiers to this program. And again, the real reason for that was initially the foundation tier is what we had, and it really only applied again to estate planning. But we now have administration, we have business tax advance planning, we have litigation. So shouldn't these benefits extend into those other departments as well? So each tier is going to affect those different departments differently. So for people who have businesses and a lot of tax concerns and things, you might be more into a legacy tier because you've got a very complex situation that's going to need our involvement significantly more often. For those of you who have your family, you're not in business, and you just want to make sure that your family and the estate planning is taken care of, you're likely more in the foundation tier. And for those who are kind of in a hybrid, you're not super complex, but you're not super simple, we still love you, but you're going to be in the heritage tier most likely. All of the tiers are going to be on this gigantic poster board outside this room. So if you have questions on them, what they apply to, how they apply, and of course the cost component, it will be out there and we will be answering questions at the break. But again, this program is not going to be for everybody, but it is absolutely there for people who are especially worried about how future generations can continue to be protected, and they want those generations to very potentially be involved in this planning and in that legacy building. Again, if you have further questions on it, we will be out there at the break to answer those. So, if you hadn't heard about the Access program, this was a quick introduction to it. If you're already an Access member, I encourage you to go grab a sheet that says what your new benefits are, and then look at what those other tiers would include and see if it's something you want to look into. All right, with that, we are going to give you guys a little bit of a break. So it is just shy of 10:30, so to keep it a clean number, we will be bringing you guys back at 10:45. For Lifestyle Financial in PJI, they are going to be out in the courtyard through these doors. For Copenbarger appointments in the Access table, they're going to be to your right, my left, out here. Restrooms are in the back corner. One thing to note, if it wasn't already said, for those of you attending today who have not already seen us or are Access members, you are entitled to a complimentary consultation with us because you are taking part of your Saturday to listen to us. So if you would like to take advantage of that consultation, where you checked in with Caitlin is where you can then sign up for those appointments. All right, I'll stop talking so you get the full break. We'll see you back at 10:45.
Not this one?
True, that would be an idea, but what I figured out is that as I was watching some people, they were shifting the paperwork. So when they're shifting, they're grabbing that. So a lot of them, like I said, from the transmitter, I think they're covering the transmitter. Because as soon as I said that, it's getting it higher, then it wasn't cutting it.
Well, they were all still getting cut out even after we changed the battery.
Well, yeah.
It's
Right.
And the thing is, because I deal with this all the time.
Yeah, me too. I mean, sounds like this in the church, but that transfer right there, I think when they were covering that, it was one or six. So we're going to have all the eyes on them.
They're all rated. Shouldn't have that much interference. You can probably go the other end of the building and not have anything else.
It's a low range, sure.
Yeah.
I mean, I bring my own mics. This is what they have.
Yeah, I've got the sure 887. Their place that I have to live where we go. We have to turn our cell phones on airplane mode because there's so much interference.
Wow.
Yeah.
The last time that we actually went.
No one else. Get a second mic I can play around.
Well, the joys of technology.
Yeah, that's why, like, down south, I can drive, bring my own stuff. Sometimes every venue has different stuff. And I come the day before and test all their stuff. And even these things like these projectors, well, there's loose up there. Yeah, that's when like move it around and just get it squared up. And it's like, it was just nuts. That's when you just get smaller. I don't remember that.
It looks like it was.
Really? Yeah, I got no projectors too. I mean, I had to actually convert VGA. Yeah, we used VGA. Right.
all the wireless stuff.
And then we were at a venue a while back where they really big Greek Orthodox church. They had this massive, beautiful, like massive. And they go, hey, we got a new system now. It's all AirPlay. And I go, okay, yeah. You got a Roku up there and Apple TV. Oh, yeah, it's Roku. It'll be great. The projector's like 40 feet up. It's like massive ballroom. I said, well, on the wall here, you have built-in HDMI, stuff for it. So like, that's looking too right. I prefer to be wired if I can. And they go, oh no, we cut all those. Like, you cut them? Like, if they're already there, why cut them? You can have it like it's a dual source and just sit back and forth. So I'm like, oh no, because we've been having problems with AirPlay. Okay, so then I'm using AirPlay there, and then all of a sudden my slides were right in the middle of it, were stopping. 4, 5, 6 times, and I'm like, what's going on? And it turns out in the main sanctuary, they were doing a big event, and they were live streaming it, and they had only one router. So they didn't do any kind of bandwidth allocation, so we didn't have a private network. So we're not to use their Wi-Fi. I don't give any of the guys there. We need to have our own channel basically, where give us bandwidth, give them a little bandwidth, and then I don't want any interruption. And they go, yeah, we didn't think about that. We've had that problem before. Yeah, so now, like I'm in there, I'm bringing like a Verizon unit that it's a professional grade one. It's got it's got antennas. You can get 5G, you get 5 bars. It works, but like I can't trust everything. So okay. Oh wow. Yeah, that would be awesome. Yeah.
Across the fellowship. All their the radio stations.
That's messy.
Yeah, it's good when it works.
Right. Sometimes older technology is better than newer technology. They're anxious to get the new technology. It's like, yeah, they go with the old technology.
I talked to her last week and she said that.
Right. I was gonna say because my church in Cornerstone Church that's in Temecula, they just started going wireless guitars, and it wasn't blending up. And there's so much else going on. They have all kinds of stuff on the stage. It's like it's a massive church, and that's your having competition. You have to go wireless guitar. You don't have enough competition with everything else. Like you have to have wireless. They do wireless everything. But they learned one Sunday when they started having competitions. Yeah, you guys gotta jump on that.
I got somebody pastor in series.
Okay.
It's complicated. He's got to make sure all his stuff within a certain frequency range.
Oh wow!
So it's not affecting them, and I'm affecting theirs.
Wow! Yeah.
If you don't understand. So if you're planning to
what if I change that?
You're planning to another state.
If I change the channel.
Because there is no technology. But a lot of aspects of that channel trust.
That was actually a question I asked this year, and then she answered it for me by saying that. Yeah, she did.
It isn't toggle between different channels. Oh, there it goes. Yes, yes. So I probably have it. They even have this right here. It's the potentiometer with the audio. That was just weird. Wow, potentiometer. It's actually I like a potentiometer. I don't know where. They have a bunch of cables that go in the back of the room. It goes to that back closet back there. They have all the equipment.
Think about moving, it's under the table. That looks like where the speaker. I'm thinking back to so that's like the old neighborhood.
It's not like it's a Bluetooth microphone because it's not Bluetooth speaker. No, I don't see anywhere else, but
I'm wondering if it's
speakers go around here, they go all around here, and then they go in that room. That's all there, in the dining room. Exactly, it's like you know, like in chamber.
so and if it's a cheaper lower end, lots of space, all that cell phone inside the line, and getting up your
Yeah, I think so.
I crack myself up. I'm so funny at this age. Read your text. I'm so funny.
That was going straight. Sounds like you get up. I know.
It could be causing the interference, but
that's why Hamel Hill is so
this right here, and again, the only reason I had to have this to show up the heat, but when I had the microphone on,
then of course
and I just had this barely moving,
because you can't
cut it out.
how you want to run your own business.
So I just unplugged it, shut it off, and now my mic's all by itself. So that might just cause some weird interference.
Good.
Yeah, it's like random. You don't usually have like dog stuff. Yeah, maybe that's what it was.
Find out. Learn something new every day.
Right?
It's so freaking hilarious. Because it's true. It's funny. Accept it. Roll with it.
All unnecessary.
That's so funny. I'm literally hilarious. Here I am going, where's the living room?
Boxes and a lot of them back there.
Oh, bummer. Well, then you need to talk to the management of the hotel and tell them you need to unlock the box. No bite for me.
$6.20 a gallon.
That cracked me up when I wrote that. Cracked me up when I wrote it. Number one, I realized it was respective businesses don't constantly try to fix each other, right? In your case, you're not like, lady, you've had enough cake. In my case, I'm not like, quit talking to them. They don't have this. They just can't help them. Your first marriage, showing the back the gas stations there, that she went to that concert with her mom, yeah. But Abby Soto, my little friend.
Actually, like when you drive 680, over the Venetia Bridge, right, the pipe actually goes down 680, and then it goes off into the marshes. Yeah, and it actually then parallels this one.
Oh yeah.
Well, they have markers there.
That's just one of the houses. Those are all houses.
The pipes are on the ground. Well, maybe in some places, but like when you go past where you used to have the all white paper, that's all they have.
I'm pretty sure she's making bank now. Hopefully she's managing it well, but I believe she is making bank. Whether she's taken the time to manage it well, I don't know that. But I hope so, because she has good intentions. She's a family girl and wants to help. And plus, if she ever does get married, the reality is she's looking at that life for her 20. So, she can't be one who was like, I didn't have any fun. Yes, she did. And you know her dad. Her dad is smart, and he's a hard worker. Hard work will get you places in life. We know that. Once you're taken off your dad, but I also think she's smart.
Some days I get up, I go, maybe I'll look at it.
Okay, you don't need more on this. That was sort of that's all. One more step. Let it go.
I already see 6 things. I'm not surprised. I think it's large.
Yeah, she said bigger, middle, top,
It's more of a it's not
what's weird is
I don't like it. Dark forest, a bunch of fruits on flowers. Not a cavalier either. She'll do whatever you want.
All I gotta say is I actually think Jesus. I was mentally engaged the whole time, but I'm certain there'll be things that you will remember that I won't, which is part of why you should be with me in the coffee cream. I don't think I will be able to in any way, so I was trying to do everything with this and copies and everything. Not touching it. That's the best thing.
Perfect. Thank you.
All right. Oh, just kidding. My cruise director said wait. Cruise director David, here he is.
Some of you guys brought extra guests today, and some of you guys got a raffle ticket.
Oh.
So, we're gonna draw one for you. Anybody lucky in here? Only one lucky person? Okay.
We're all lucky.
All right.
Not even in there.
58015
Keep going.
65. Ending in 1565? 1565.
Is that you?
Hands up? All right, we got a winner. As we say, winner, winner, chicken dinner.
All right, there we go. So, turn the speaker.
Yeah.
Oh, Lord. Yeah, I don't know.
There you go. Perfect.
Okay. Oh, now it's at me. All right. So we're not tech people. That's what that just told me. All right. With that being said, I'm going to bring you guys back, and you are going to get to hear from Catherine. Maybe, if this mic holds out. Catherine, as I mentioned, is part of our business tax and advanced planning. She's actually the head of that department. She had been working in-house at a number of larger corporations before we poached her and said, come help us and help our families that need it. So she's going to go into a little bit more of the in-depth side of things that goes above and beyond just the basic estate planning. Hi, Emma. And she's going to be focusing on those components. So here is Catherine.
Thank you so much, Victoria. All right, well, the section that I'm going to go over, we're going to start with sort of a second half of some legal changes, and then I'm also going to get into some advanced planning and what that looks like and how we can potentially help you or someone you know, maybe another family member or relative. So the first thing we want to cover, and we cover this every year because all of these numbers fluctuate, the rules themselves hasn't fluctuated, but the numbers themselves fluctuate, and so we always need a refresher there. Kick back in. So the first thing, we're looking at federal taxes, federal estate tax. So right now we're at 15 million, meaning that if you pass away and your estate is under 15 million, you don't have to worry about the death tax. However, this number fluctuates a lot over time, especially as administrations change. It can kind of yo-yo back and forth quite a bit. So right now we're at 15 million, and that if you're a married couple and your estate is close to that, come in and see. You're probably going to start the conversation with Victoria, because one solution is to get a trust that splits as an A-B trust. So for example, you have an older trust, maybe you started it when you were younger with our team, and now your assets have grown exponentially. You're looking at something closer to that exemption at least. You don't know where it could be once you actually pass away. So you need to have that review again, as you should be reviewing your trust at least, every 5 years or so. You want to have that review to make sure you're staying ahead of legal changes, but then to also make sure you're staying ahead of this specific legal change as that estate tax exemption fluctuates, because it can dip down quite a bit. And if it does, then you're definitely going to want to look at that easier solution, that split A-B trust with our estate planning team. Now, if it's significantly more, if you're looking at 15 million per person, so that A-B trust essentially is a solution that allows you to each individually claim that 15 million exemption as a married couple. If you're very fortunate and blessed and you're looking at hitting that estate tax exemption, or potentially someone who is, as a married couple, then you'll look at also alternative planning. So let's say you're so blessed you have an estate, you're a married couple, you have an estate closer to the 30 million, you've already set up the AB trust. Then we need to talk about some other advanced planning techniques and trusts and other ways that we can avoid that estate tax, on any unnecessary estate tax. So that's the estate tax exemption. One other, and then I also want to cover the gift tax exemption, which fluctuates every year as well, increases with inflation. Right now we're at about $19,000 per person. What does this mean? What is the gift tax exemption? So this means that every single year, every single one of you could gift, if you're generous enough, gift up to $19,000 annually. So that's over the course of a calendar year, you can gift $19,000 and not have to claim it. The IRS doesn't need to know about that. If you exceed that amount, that's when you need to look at filing a gift tax a gift tax return. And I know we're like, I'm not going to gift that much, but let's think about if we have children who are now trying to step out into the world. You want to set them up for success. Maybe you're generous, you're gifting them a valuable car or a lump sum, you're paying off student loans, helping them get their life started. Those are likely or very easily going to start to exceed this $19,000 per person gift exemption. So if you are gifting, and if you're especially gifting something in excess of this value, please come to our team and we can help you quickly file a gift tax return. Another thing that I want to sort of jump back a little bit to the concept of the estate tax exemption is also the portability rule. It is a tool that we can use. So whenever there's a couple of variables, as I've already mentioned. We do not know what the estate tax exemption will be at any given moment. With some, we sort of do, but sometimes we cannot predict what it'll be. We can also not predict when you're going to pass away or when your spouse is going to pass away. The portability, this portability rule is a tool that we can use in order to sort of lock in. If your spouse passes away when the estate tax exemption is nice and high, like it is now, if you claim this portability, and it is time sensitive once your spouse has passed away, so please make sure you're seeing our trust administration team. Megan will speak after me. That's the team, and that's a team member that you're going to want to go to in order to look at making sure that you've locked in this portability. Essentially, what you can do is port over any of the excess that wasn't used. So let's say your estate is not hitting the estate tax exemption because it's nice and high. There's excess to use, but you don't need it. Your spouse passes away. It plummets. You pass away. You would have to pay an estate tax on whatever the your estate value is at that time, because that estate tax exemption has plummeted at the time of your death. If you filed for the portability when your spouse passed away, then you can actually port over that unused portion and avoid the unnecessary death tax. Okay. That's all. That's what come on. Okay, there we go. That's what I wanted to cover on some of the gift tax, the estate tax exemption, and then also portability with regards to that last one. Can I take a quick poll? Just raise your hand nice and high. Do you have, does anyone in this room have a property that they rent out? Okay. Do you have, perfect, I actually recognize many of you, I've talked to many of you. So this is probably just gonna be a refresher. I'll try and go over it quickly. Does anyone have a business that could be, it's a rental property? Let's say it's not, because the rental property I'm assuming is a business, at least whether it's registered or not. So separate business owners. One thing that the team can help you with, and this is more of a plug to the resources that we have rather than legal updates. Tenancy laws change every year. That's why it's in this section. Also, employment law changes every year. So if you're a business owner with employees, or if you know someone who is, please know that you can come to us for some consult with regards to how employment law has changed, if there's any new notices, anything like that. If you are an independent contractor or you're doing consulting work and you want to figure out, do I need to set up my own business? Can I get, I would like my consultant agreement reviewed, anything like that. Those are actually services that we can provide in-house too with our business department and employment department. But tenant laws especially change over time, and that affects more of this room. So if you're a landlord, I plug a couple of the what I consider the most impactful changes. So one being, let's say you have an ADU and perhaps it had a smaller kitchen or kitchenette. Note that working stove, working fridge are now included in the habitability requirement for that unit. So make sure that you are providing your tenants with a working stove and working fridge. Also, if your tenant cannot pay their rent and makes a claim because of the Social Security benefit delay, that is also a hardship. That is also a hardship defense, meaning that they're for the time sort of exempt from paying, or they can sort of get away with it. Yeah.
This excludes commercial property?
We're talking about residential, yeah.
Okay.
Residential right now. Great question. So this actually happened last year. If you were here last year for a seminar, this was also in the slides, but I like to plug it because it's important to remember and it's easy to forget. If you are starting a tenancy with a tenant, take before and then after, once they've moved out, photos, or else you will no longer be able to claim deposit, the security deposit for any issues with the property. Also, if you have any work done, if you have essentially any work done on the property, take before and after photos for that as well. I'm done with that, Mike. This next section is our advanced planning section. So my department is business, tax, and advanced planning. Another attorney that I work with specializes in that advanced planning wing of my department, Kevin Vandenbroek. So especially if you're looking at one of these 3 bullet points, if you're looking at the estate tax exemption, you're looking at potential death tax exposure because your estate is so high, please come. We'll set up a consult with Kevin. If you also, maybe you have estate tax exposure, maybe you don't, but you specifically have charitable intent. There are a lot of different things that we can do depending on what you want to accomplish. If you want to set up a nonprofit, or if you want to set up a private foundation, you'll probably be talking with me. If you want to set up a charitable trust that then gives to specific charities, either during your lifetime or after a certain period, after your lifetime, then I'll have you probably talk with Kevin. These are all unique sort of advanced planning that we can do in the Copenbarger team. Also, if you have interesting assets, and I kind of just couch lots of different non-liquid assets in here because we're also just talking about real estate. Real estate can have some unique ways that we want to manage it, like setting up a business to manage it if it's a rental property. And I'll talk a little bit more about that in just a moment. If you also have highly appreciable assets like certain stock, that may be something that you really want to come and talk to our team about. Because you want to be careful about how you transfer them, what you're doing with them, avoid capital gains tax that's using certain, I'll just say, I'll probably have you talk with our tax attorney, Kevin, and figure out a strategy that helps you avoid something if you want to shuffle off some of those highly appreciable assets. So I've already mentioned so with the estate tax exposure and reaching out with our attorney Kevin, a lot of what he's going to be working with are irrevocable trusts. So what Victoria talked about earlier was your revocable living trust, meaning that while you're still living, you can still manage the assets. Irrevocable trusts say once I put it in the trust, the trust controls it. I, as an individual, no longer control it. It's no longer just this very flexible pass-through trust. I'm setting up an irrevocable trust. I'm putting assets over into it, and the IRS is saying, okay, we recognize that those are no longer your assets. They are assets of the trust, so you don't have to worry about certain taxes on them. That's why we look to irrevocable trusts with a lot of this estate tax exemption exposure, because we can shift assets off of your estate. Again, I heard Victoria mention the QR code at the bottom. More in-depth presentation here, okay? And I actually already touched on a lot of these. So, yep, we can set up private foundations, nonprofits, churches, depends on what you want to accomplish. Our team can help you do that. And then also certain types of trusts that give. Now I'm going to go just a little bit more in depth to all those second property owners that have rental properties. So what comes with that rental property? A lot of liability. Whether you have squatters, tenants that won't leave, you're trying to evict them, you need to loop in our litigation team. You'll probably work with Elaine Alston, she's our head of litigation, or potentially one of our newer attorneys in the litigation department that just joined us last week as well. He's out of our San Jose office. He's a little bit closer to you, so you might actually work with him as well. But one other thing that I want to talk about with real estate, so for that investment, like I was mentioning, there's a lot of liability around it, whether it's a slip and fall, whether it's accidents, whether there is any number of liabilities that could happen, especially for a rental property. You're operating that as a separate business that's generating income. One thing we can do is create an LLC for it. What the LLC, and I picture it a lot of different ways, but my favorite lately is to actually think of it more as a cage. It's called the corporate shield, or the LLC corporate shield, liability shield, and piercing a corporate veil are terms that you'll hear a lot, but really we need to call it something that like encloses. So you're saying the assets that I put inside this LLC, namely the property and anything else that I put inside, those are in a cage. If there's anything that happens or related to that business, any of those liabilities are also just in the cage with those assets, meaning that you're keeping all of your other assets, your nest egg, your liquid assets, or potentially your other rental properties, if you're isolating them with individual LLCs. You're keeping your other investments, your nest eggs, you're keeping them separate from that liability, meaning that A court order it can't be touched, okay? As long as you're operating the LLC appropriately, you're protecting the rest of your assets from the liabilities of that asset. Because of all the liabilities around rental properties, I strongly encourage any individual who has a rental property to put it into an LLC. One of the LLCs are very easy to run and manage, generally speaking. One of the costs of them is just going to be an $800 annual franchise tax typically, and some other small minor fees. So you're really looking at not too much a year for full liability protection. A question that I get a lot about this though is, what about an umbrella insurance policy? Isn't that good enough? And the answer is yes, and it's not good enough. They work together. So if you go back to that imagery of a cage, what you're doing with the insurance policy is you're saying, I'm going to insure all of what's in that cage to try and protect it from itself. But that protection of the cage is, come on back. There we go. But that holistic protection that cage provides from all of your other assets is unmatched by the insurance policy. The insurance policy is going to have a limit. It's going to have caveats. It's managed by a third party, the provider, the provider. It's not going to be the same. Your LLC, if a court tries to attack some of your, or if someone tries to attack your personal assets, the court's going to say, nope, there's an LLC. That's the objective. Totally function separately, and I like to think of them sort of as that insurance policy is covering what's inside the cage itself is shielding everything else you have.
Quick question?
Yep.
Doing that with an existing property will reset the taxes though, correct?
So what we're doing with the LLC is we're trying to, and you're talking about property tax.
Correct.
Right?
Correct.
Yeah.
Yes.
So as long as we are making an LLC that is proportionate in interest to the current ownership of the property. So, and this can also occur with multiple properties. So let's just use a simple example though. Let's say, let's say like brother and sister own a property half 50-50. All we need to do is set up an LLC where brother and sister own that LLC 50-50, and then we qualify under a proportionate interest transfer, and the property isn't subject to reassessment, and so we're looking at the same property tax. Yes, great question. Please feel free to raise hands. I enjoy the questions. Before I turn this over, I just have a couple more quick comments to make. So for highly appreciable assets, like I mentioned before, if there's something they carry a lot of risk because they carry a lot of potential capital gains tax. So before you start moving them anywhere, I recommend you come to us. Maybe even before you're at that stage, maybe come to us for some tax planning. But this is what we're gonna tell you is gonna vary depending on what type of asset it is. So I'll just say, come talk to us if you have any questions. And we talked a little bit about a business. All I really wanna touch on these last two slides, sorry, I'm jumping back and forth between them to just make sure. All I really want to touch on these last two slides is that we can consult and help with a lot of different types of businesses. So please feel free. If you're soft retiring and want to do consulting work and want to figure out how to do consulting work and setting yourself up still for success, making sure that you're getting the right agreements in place, whether you're setting up an actual business and registering it, likely you're going to be setting it up as an LLC. But come talk to us if you're planning on doing any consulting work, any type of business. If you have an existing business, we can help you out with that. We actually have a pretty robust skill set, including, intellectual. I come from a background of working in-house at tech companies. Of course, I have an IP and data privacy background and knowledge if anyone ever needs it. We also can consult with employee matters, like I mentioned. Yes?
Does it matter what state you have the LLC?
It depends on what you need consulting on. But if, for example, you just need general, like corporate governance or LLC governance, making sure that you're filing everything on time, state to state, we can usually do most other states. If you need to set up an LLC in another state, we can do that. If you're looking at more specific, maybe it's back up, there we go. If you're looking at more specific, like employment law, that's going to vary a lot state to state. So we may at some point say we need local counsel for that. Yeah, but usually we can cover a lot of material, and then when we can't, we'll let you know. Yeah, and we can try and refer you out. Okay? I think that is the end of my section, and at this point, I'm going to call up Megan from our trust administration team. And she's gonna talk for a lot longer than me, I think. I'm sorry. Take it away.
Thank you. Okay, so my name is Megan, Megan Wilson. I like to consider myself the fun one. So please bear with me, but I'm gonna cold call people. We're gonna treat this like law school. You're gonna hate it, but you're gonna learn a lot, okay? All right, so we're gonna go over trustees' duties today. So how many people in here have a trust? All right, fantastic. So you guys should have already set out your trustees, right? You've picked people that you think you trust to take care of your estate. So essentially what happens when you come to my side of the department, right? So estate planning is when you go and you paint this beautiful picture that's called your estate, and you let it grow over your lifetime. When you pass away, you come to my department. We help you evaluate it. We help you avoid the taxes that you've established inside of your trusts, and then we help gift it to your kids to make sure that it is going to actually maintain the benefits that we put into that trust in the first place. Okay, so that's the difference between the two departments. So here, what we're looking at when you guys come to us is not only are people grieving, and they grieve very differently, right? So some people are very emotional for a long time. Some people are like, I'm ready to get this thing done. I need something to get my mind off of what's going on, right? So our team in the trust administration department, we help with this process. We take a lot of the stress off of the trustees' shoulders and try to move people smoothly through the process called trust administration. Now, it is quite a process. It's usually anywhere between 6 to 8 months. Okay, it's because we have a lot of stuff we have to do. So we try our best to make sure that we walk our trustees through what the trust is, how it functions, who it's going to help and benefit, and what's required of them to keep all the liability off their shoulders, if at all possible, okay? But I also want to let you guys know that when you're picking a trustee, it's really important to know who you're picking, right? So how many here have more than one kid? A lot of kids. How many have 3? How many decide to make all 3 your trustees? Fantastic, love this crowd, okay? A lot of the times, estate administration will say, yeah, all your kids can be trustees, that's fine, we love that. We hate that in trust administration. Let me tell you why, right? When you have multiple trustees, it becomes a little bit like Congress, right? One trustee wants to sell the house, the other trustee wants to keep it, and one in the middle just wants his cut, we're like, what do we do, right? Now we're stalemated, right? So your 6 to 8 month process now becomes 1 year to 2 years. Right, and now everybody's frustrated and they're looking at me like, Megan, you have to solve it. And I'm like, well, I'm just here to help facilitate it. I can't make the decisions. You have to, right? So my recommendation is pick one person that you trust. If you're like, but I love both my kids, who's actually responsible, right? Because you might have that one kid that's your oldest, but maybe he's not so good with finances, right? Maybe it's your youngest who's actually in finance and knows what they're doing a little bit, a skosh, right? Or maybe both of your kids need a little help. That's how my brothers are. That's why I'm the trustee, right? So I would recommend making sure that you know who your trustee is going to be, because they're going to have a lot of discretion regarding your assets, okay? Second, know who your beneficiaries are. right? If your kids have a tinge of greed, make sure you're involving them in this process, right? If they're like, when mom passes, I want my money and I want it now, right? We want to make sure that we're communicating to the kids like, hey, this is what this process looks like. It's going to take 6 to 8 months. Don't hassle your brother. Don't hassle your sister. Let them get through that process. Trust them because I trust them, right? I want you guys to remember that during lifetime, you guys are the judge. When you guys pass away, it's an actual court, right? And I'll say it like I tell all of my clients and like I tell my family, the only people that win when we go to court are attorneys. Okay, so it's my job to try and keep us out of that, but I need you guys to help me with that by telling all of your beneficiaries and telling your trustees, this is what this process is going to look like. It's going to be long, it's going to be arduous. Nobody likes it, but we'll try and help you get through it as best as possible. And patience and transparency needs to be provided throughout, okay? So let's talk about the process. I'm going to skip to the process. Okay. So the first set of things that we actually have to do through an administration that most people don't realize, and this is why our administration takes usually between 6 to 8 months, is we send a list of notifications out. Okay, so we're notifying the assessor's office, the recorder's office, we're notifying the Department of Healthcare Services, we're notifying beneficiaries. Does anybody know why we notify beneficiaries of the fact that a trust administration is taking place? I see no hands. I don't like that. I don't like that. Okay. What's your name?
Rhonda.
Rhonda. You have kids?
Yes.
How many?
2.
2. Okay. I'm going to be your eldest, the one you trust. You're like, Megan, love you. I'm going to make you my trustee.
That is our oldest.
You pass away. That's a great name. So let's say you pass away, husband passes away, right? It's now my job to administer your trust. But I don't tell my sibling anything. Nothing. Okay? I started this process with a cute little Kia. I ended with a Corvette. Who has problems? Right? Right? If you're the other sibling, you're like, whoa, what the heck? It's been 6 months. What's going on? Right? So you're going to have a lot of questions. So that's why we send notices to the beneficiaries. It's to tell them what their interest in the estate is. We want them to know that this process is taking place and that they're required to information. Right? That's very important. So that when I have that Corvette, my sibling can say, where'd you get it? And I go, mind your business, not from mom's estate, from my own. Right? And then they're going to say, well, I want to verify that. Oh, well, you're entitled to it. Let's talk about some of the things that trustees have to do. These are trustees' duties. Okay, now these are actually very important. And this is just a little list. If you guys want good bedside reading, I would say take a look at this probate code. Okay, this is what all your trustees, this is primarily a lot of my job, is to keep them in line, right? Cannot favor one beneficiary over the other, right? So if there are sibling rivalries, we see that all the time. Or sometimes there are siblings and churches, right? And we're obviously going to favor our family over some church, right? Because that makes a lot of sense. It doesn't. But we see it all the time, right? So we want to make sure that we're avoiding conflicts of interest, right? So I'm not going to put all of mom's assets into my estate so I can benefit from the interest. I've seen that happen. We got to make sure that you're not commingling assets. Remember, I mentioned taking the estate and then having my own car. The best way to state that you're not commingling or to identify whether or not assets were inappropriately used is to make sure that assets are completely separate, right? So if I send a beneficiary a copy of all of the bank statements that have happened from mom's estate and dad's estate, and they're like, oh, well, I didn't see any kind of Corvette purchase. They're gonna have all their worries likely go away. Now, they're not gonna like the time period, but we can't really fight that. We have to send all those notices out, and unfortunately, California does not run expeditiously. They're much like Congress. They run on their own time. So it does take time. It does take time, but we do our best to make sure that we're abiding by these requirements, right? There's formal accounting periods. We have to provide information that way other beneficiaries know what's going on in this administration. We can't just have one trustee say, I'm not telling you anything, I'm doing it because I have to, and the attorneys are working with me, and that's it. That's not how that works. Right? But we do try to make sure that we're maintaining the relationships between the family. We do let them know, trustees, it is your obligation to speak with the beneficiaries, to let them know, relatively speaking, what's going on with the administration. They have to give beneficiaries what we call reasonable amounts of information. Now, here's what's funny about that term reasonable, right? Who knows what that means? Fantastic, me either. That was a trick question, right? It's ambiguous for a reason, right? So if I'm giving you weekly updates, more than less likely that's reasonable. If you're a beneficiary and you're requiring me to give you minute by minute, transaction by transaction updates, not reasonable, right? That's just too much. So these are in place to make sure that beneficiaries know what's going on in the administration and feel confident in the actions that the trustees are taking. But they're also in place to make sure that the trustees do not abuse the control and the power that they are given upon your passing. Make sense? Alrighty. Let's keep moving then. We don't need to talk about time management, but what we will talk about is records and requirements. So one of the things that we keep talking about here is money. And I know you're probably thinking, why do we keep going back to this idea of accounting? Because really this is where a lot of the fights happen, right? So siblings will say, it's been 6 months, what's happened with the estate, right? If you're going through an administration and you have no idea, because most people don't know how long this time process, how many people knew this would take a 6 to 8 months when they walked in this room, right? I see like 3 or 4 hands. There's like 50 people in here, right? So imagine what your beneficiaries would feel. 6 months after mom's passing and nothing's happened. There's barely any communications. They're like, we got this trust packet that says we're supposed to come into 1/3 or 1/2 of the estate and we haven't seen anything. So that's why time management is really important, but also why transparency is really important, right? So we implement making sure that the trustees make monthly communications with beneficiaries to make sure that everybody's involved in the process, but not so much so to overburden and or overcharge the estate. Okay, we're also providing a lot of information regarding accounts because they can be expensive, and those are the primary reasons why people end up in litigation. And like I said, nobody wants to go to court except for attorneys, okay? So this brings me to my greatest pivot, right? What happens when trustees and beneficiaries don't get along? Ding, ding, ding. We're in court, okay? Again, when you're defending a legacy and when you're defending what your trustees' actions are, our firm takes 2 stances. We can either represent the beneficiaries or the trustees, right? Again, during lifetime, you guys serve as the judges when kids fight, right? So I'll give you guys a primary example. My dad, he's got an antique car that he works on. It's just his prized possession, likes to go outside and wash it and just watch the sunset, right? My brothers and I, we've all put dibs on it. We've all put dibs on it. So I know when my dad passes away, if he doesn't specifically state who that car is going to go to, we're going to bicker about it. And I love my brothers, but I'm going to win that fight, right? Right? That's every kid's mentality. And I want you guys to understand your kids are no different, right? They're no different. So whatever is important to you guys, I want you guys to understand it's likely important to your kids, right? And it doesn't even have to be dad's favorite car. It can be mom's wedding ring. It can be a toaster, right? Because it has a lot of memory or a lot of sentimental value. This is what we fight over. And when you guys are alive, you guys can separate those fights. You can stop them before they happen. But when you pass away, we end up in court because kids dig their heels in. I would dig my heels in for my dad's car. I'm digging it in. Also, I have my license, so it really is not going to cost me much, right? It's going to cost my brothers. So it's a little different, you know? That said, there are some other things that drag families into court for litigation purposes. Poorly worded trusts, right? So if we have ambiguous terms that are in those trusts, or I have seen quite often settlors say, well, I don't want to go back to Copenbarger. I'm going to just put a line through this, and put what I want, and then put a date. We're going to end up back in court. You want to know why? Because I'm going to see that amendment and go, there's no signature, it's not valid. Or it's only crossing out exact words that are through the line. Everything else is still valid. I've seen both of those arguments in courts, and honestly, because probate courts or courts of equity, it's going to be up to the judge. So I like to call the probate courts the Wild Wild West. Okay? So if you're thinking about whether or not you want to amend your trust, call us. If you're thinking about whether or not you want to put a line through something, really think about it smartly, because if attorneys get involved, it's just going to cost your estate. And unfortunately, it is going to come from your estate. It's not going to go to your kids. It's not going to benefit your kids. They're just going to end up fighting over it. Okay, so these things are really important. The next thing, incomplete documents, right? So I've seen a trust. It said all of the important things, Med-Cal, disabilities, all of these things, and then it said distributions in the last paragraph said all of my estate to, and then I turned the page and it was blank. What a disaster. What do we do now? Do we treat this like a trust? Do we have to go to probate? Right? We're all racking our heads. We had no idea. We had to go back to the drafting attorney. He was retired. He had to go through all of his stuff. I say this to say, what we're trying to do is make sure that we can keep you guys out of court. So if you're getting to your point where you're looking at your trust and you're like, should I go into Copenbarger? I want you to read that thing and go, okay, if I died today, am I okay with what's on this page? If you say no, you need to make an appointment. If you say yes, have a great day. That's it. Okay. Okay. Another reason why we go, and this is actually, unfortunately, this is probably the saddest part of my job, is because kids can be greedy. Right? Like, I will dig my heels in for my dad's car, so I fall into that category. I'm not judging. But kids can be greedy, and kids can be needy really quickly. They want their money and they want it now. I see it more often than not, right? Which is why I always advise all of my clients, please tell these people, please tell your beneficiaries, tell everybody, it's gonna take some time. It's gonna take some time. Now, I will tell the trustee, tell them it's gonna take 1.5 years. That way, when we get it to them in 6 months, they're happy, you know? They're like, woo, thank God, no fights, right? But kids really will, and they're adults, right? You're thinking that they're not gonna fight, but when parents pass away, that grief process kicks in, and you don't know what's going on through their mind, and we don't deal with them, right? We only deal with the trustee. So a lot of the times, these things take place in courtrooms because there's no communication, because kids are getting impatient. So if there's communication beforehand, I promise you, you can bypass a lot of the litigation that you won't even live through. Now, I know what you're thinking. Well, if I'm not there, right? No. Don't make my job hard. I don't want to do this. I don't like fighting. You know, I'm a lover. I'm not a fighter. That's why I picked this area of law. And this is why I'm telling you guys these things. You guys can prevent all of the fighting, all of the litigation by just having these conversations with your kids, okay? Or your beneficiaries. So yes, we defend trustees, right? So a lot of the times our trustees will be working with us. We will keep them between those. We'll make sure that they're abiding by all of those trustees' duties that we showed you and all the ones in the probate code that I did not put on this slide. But when beneficiaries get impatient, when they get greedy, or when they think that there's something inappropriate going on because our trustee's not following our monthly update, right? Then we defend the trustees in their actions. Sometimes though, and I've actually seen, and I actually spoke with somebody today who said, well, what if the trustee's doing something wrong, right? What if the trustee hasn't distributed? I have a file actually on my desk. I'm representing a beneficiary. Their parents passed away 10 years ago. 10 years. Nothing's happened. Nothing's been distributed. And he's like, what do we do? Well, how do I handle this? You know, I don't want to fight with my sister, but at the same time, Megan, you know, what's reasonable here? And I'm like, certainly not 10 years, right? So we get in and we get involved and we represent beneficiaries. This is how we send letters and we say, hey, get to it. Doesn't have to be us, but you got to find somebody to help you get through this process, right? We got to make sure that it's done appropriately. We have to make sure that all the notifications are sent out, so that way the estate is handled appropriately, so that the taxes are handled appropriately, and so on and so forth. So we do represent both parties. We will not represent both parties in one matter, in one family, so don't send everybody to us. Just kidding. but that said, we do our best to handle all of these litigation issues with the utmost care, but we do our best to try and stay out of litigation if that's possible. We talked about greedy kids. We did. We talked about that too. Okay. Other cases that we handle. So we do determination whether or not property should be probated. We look at whether or not there are asset disputes, whether this asset is classified as a trust asset. We look at investments for assets. Were the assets properly maintained during this trust administration, right? So if you have a brokerage account and somebody just liquidates the entire thing, was that a good action? Sometimes beneficiaries will fight over those kinds of decisions. We definitely do those. We help remove trustees if they're not doing something appropriate, and then we will help walk the court through who should be established if the trust is silent. We also do undue influence claims, right? So if mom and dad are living with, let me get your name. Paul. Okay, Paul, do you have how many kids?
None.
No kids? Best friends?
Pardon?
Do you have any best friends?
Yes.
How many?
One.
One best friend. Okay, great. So Paul's got one best friend. Paul's gonna, in 90 years, he's gonna lose his mind, right? Because 90 years, he's gonna be like 150. Anywho, he's gonna lose his mind, right? When he loses his mind, his wife's gonna be right by him like, nope, I love you, Toots. And he's gonna be like, nope, my best friend's gonna take care of me because I don't wanna put this burden on your shoulders. Now, Paul's best friend says, well, I deserve a trustee fee. Red flag, right? Well, wait a minute. I thought you loved him. I thought you guys were best friends. Okay, second red flag. He's like, my trustee fee, I'm just gonna make up a number. I think I'm worthy of $4,000 a month. Whoa, that's crazy. What are you doing really? right? Who else is sweating? Is it just me? Okay, all right, right? And it just keeps going and keeps going and keeps going. Now, what can the wife do? The wife can say, he doesn't have the right mind to make these decisions. He cannot be giving out this kind of authority, and that trustee fee is outrageous, right? Those are all influences that he, Paul, who is incapacitated, can't make a decision for. So he should not be legally bound by those decisions. That's what undue influence is, when somebody is taking a guardianship kind of role over an individual and then making financial and or bodily decisions on their behalf, okay? So we take on all kinds of other issues as well outside of trust administration. So if you're thinking, well, I've got a contract case, I've got an elder abuse case, personal injury, or wrongful death, you can bring them to us. And if and when in doubt, we have a fantastic referral network. So there's a lot of things that come to us. If we don't have the requisite expertise, we do have referrals that we send out, okay? And that's pretty much so it. Again, we really want to avoid litigation because nobody wins except for us. Now, we'll take it, but we don't want to, okay? So that's why we do these seminars. We try to give you guys what you need to make the best decisions moving forward and to protect your families from us and from themselves, okay? Who should you refer? Everybody, right? Family, friends, special interest groups, your church, your enemies, we'll take them, that's fine. You know, everybody. Everybody needs a trust. And I know when I was actually speaking with my family, I have a lot of younger siblings, and I know what you're thinking. She's 12. I'm not 12. But but when I was speaking to my younger siblings, specifically those that just graduated from high school, right? They're like, we don't need Megan's services. Yes, you do. Yes, you do. What happens if you get hurt? You need a durable power of attorney. Somebody has to take care of you. Mom and dad can't do it anymore because you're 18, right? What happens when you make a bad decision and you can't use your mind anymore? Or what happens if you get, like, life has a way of lifing, right? Mm-hmm. So we just want to make sure that everybody has the requisite documents to make sure that they're protected. And if you're a parent and your kid's graduating from high school, I know what they're thinking. I want a new car. You get them a whole fancy set of estate planning documents. They're not going to know what hit them. Okay? That's for you guys. All right, booking appointments. If you have questions, again, I want you guys to just sit with that question. Do I have my estate in order? If I died right now, this moment, am I comfortable with what's said? If that answer is no, if you're like, I don't, book an appointment. Okay, book an appointment. Yeah, we have tons of experience. We have tons of attorneys. Some are not so fun, some are fantastic. Use that green sheet, and if you're thinking about giving us a rating, you can put Megan 10. Everybody else, be honest, you know? Other than that, it's been an absolute pleasure having you guys. Thank you so much for coming.
Thank you.
Megan gets a 10.
Thank you. Any questions? I meant to ask that before I turn the mic off, but does anybody have any questions for me in general? Going once, going twice, sold. All right. Thank you.
Yeah, or you can do it at your own time.